This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon to everyone. Before we have Mr. Hibner call the case, we don't anticipate any technology-related problems, but if we should have any, everybody take a deep breath and we'll pause and get them resolved. Call the case, please, Mr. Hibner.
Re Adaline D.
We're here from counsel for the appellants. I understand that you have divided the time equally, 5 minutes to start and 2.5 minutes for rebuttal. Is that correct? All right, proceed. Whoever's talking. Yep, there you go. Thank you.
Muting yours. Good afternoon, Your Honor. Thank you for this opportunity to apologize, Your Honor. We're having some technical difficulties.
Stop the video. That's right.
Okay. I apologize, Your Honor.
No, that's not all right.
That's fine. Thank you for this opportunity to.
Just a second, counsel. We lost somebody, I think.
Mr. Bennett, if you're gonna have to turn the audio of your computer off or put in headphones, because Mr. Logue's microphone is coming out of your computer and then back into Mr. Logue's microphone.
I can do this.
Okay, so who needs to turn their audio off?
Oh, is that better?
Yes.
Thank you for that, and I apologize for that. Good afternoon, Your Honors. Thank you for this opportunity to argue on behalf of my client, Miss Kayla Nichols, in front of your court. Miss Nichols is sitting beside me, and she is appearing on Mr. Bennett's screen. We are here because we are appealing the Chancery Court of Cumberland County's September 17th, 2020 oral decision, which was signed and filed by Chancellor Thurman on October the 29th, 2020. That ruling was on a petition to terminate the parental rights of my client filed by the petitioners on September 20th, 2019 for the children Adaline and Lila, who are the subject of this case today. We are appealing this decision because we feel that that decision needs to be reversed, because there was not sufficient evidence to show that by clear and convincing manner, my client, the mother of those children, Miss Kayla Nichols, willfully failed to not provide child support in the 4 months preceding the terminations petition being filed, as well as willfully failing to visit the children in that 4-month time period. Additionally, we feel that there was insufficient evidence to show by clear and convincing manner that my client has failed to manifest a willingness and an ability to parent the children in question. And finally, that there was, we do not feel there was by clear and convincing evidence to show that it is in the best interest of these children to terminate my client's parental rights for the children. In addressing the ground of failure to provide child support for the children, we do not feel that that was a willful failure on my client's part for the 4 months preceding the termination, because as cited to in the record at page 107, my client, Ms. Nichols, testified that she was unsure of the address of the petitioners to mail child support money. Additionally, at the record at 117, she stated that she mailed Christmas presents to the petitioner at the address that she, at the trial court, now the appellees, what she thought was their address, and requested a response but received none. This was a portion for why she was apprehensive in mailing child support payments. We do not feel that that rises to the level of a willful failing to pay child support. Additionally, Your Honors, as it relates to willfully failing to visit, the statute defines willful in regards to willfully failing to visit as aware that a parent has a duty to visit, that a parent had the capacity to visit, that a parent made no attempt to visit, and that the parent had no justifiable excuse for their failure to do so. We would also like to draw the court's attention to the case Re Adaline S, 2020 Tennessee Appellate Court, Lexus 322. To quote that case, it says that often the court can consider prior events to the relevant time period to determine if interference occurred as it relates to, again, the willful failure to visit. That case goes on to discuss that the often legal precedent that courts use, that parents are not required to seek court assistance to enforce previously ordered visitation rights. Your Honors, Ms. Ryden testified at the record on page 174. Ms. Ryden, the appellee, testified that if the mother and the father, in this case, your name, sir? Tyson. Mr. Bennett's client, Mr. Tyson, that if they would seek visits, she would request that their counsel would call her counsel to establish a visit. She also stated that no visits were asked. The February 14th, 2019 order in the juvenile court for Cumberland County leaves supervised visitation up to the Ryden's discretion. And Exhibit 12, Your Honors, of the record shows that my client in text message form asked numerous times for visits to the children. And there was never a response in text message requesting that my client's counsel get with the appellee's counsel to establish the visitation. So, Your Honor, even though this occurred after the 4-month relevant time period, the logic of Henry Braylon S. seems to be that if there was interference prior to the 4-month time period, that could indicate a possible interference during the 4-month time period. We would ask this court that logic should hold true after a petition has been filed. If a parent seeks out visitation, constantly asks for it, and doesn't receive it, then maybe that would indicate interference during the relevant 4-month time period prior to the filing of the petition. At the trial court level,
Counsel,
Yep.
you used your time. You've
Okay.
used your time, sir. We gave you a little extra.
Oh, I can save my time then, and thank you.
Yeah, you've got your time for rebuttal. Here's from the other appellee's counsel.
And then,
Yeah.
let's see. Your Honors, thank you for hearing us out today. Let me just point out a few things. First of all, I think that my brief clearly addresses my client's objections to the various findings by the trial court. But I would like to address things on a different level, one of which is that I'm recalled, or I remember that June 6, 1944, America had its worst day of casualties of American soldiers ever when we invaded the beaches of Normandy. Yet at the same time, we consider that a great success. We consider that a great win for America. In any other universe, except in the area of termination of parental rights, these parents' story is a success story. We shouldn't even be considering whether or not to terminate rights of these parents, because they took what they had, which was just a total train wreck of a life. They went into court-ordered rehabilitation and they fixed it. That is a success story everywhere. We have to look at what we're trying to do in the juvenile setting. The juvenile law is set up to protect, preserve, and restore families. Yet at the same time, we use those same codes. The trial courts, and even now the legislature has become involved in it, are using these same laws to not only terminate parental rights, but demonize parents far and above anything that they ever did for custodians, foster parents, or anyone else. We force parents to do things. We order them into rehabilitation, which is a good thing. But yet at the same time, we use that rehabilitation as a reason to terminate their rights. And we can't do that. You've heard the argument about not paying, but again, both parents were in a drug rehabilitation center. They weren't working at the time because they were court ordered to be there. Equally important, I will go even farther than Mr. Logue was going. The record doesn't indicate, in my opinion, the record is clear that the paternal grandparents interfered with these parents' visitation. Even before Lila was born, when we were talking about only a single child, the grandmother forced the mother to meet her at McDonald's at 6 o'clock in the morning to exercise whatever visit she gave her at the time. You're not going to be able to nurture a relationship between a mother and a child at 6 o'clock in the morning at McDonald's. They did everything they could to interfere with visitation, including made a call to the guardian ad litem, which is part of the record, that says the grandmother wanted to know what she could do when the parents called because she didn't want to give them visitation. So those two issues, I think abandonment issues are failed simply because of interference by the custodians.
Counsel, are you talking about interference during the relevant 4-month period of time or some other time?
During the relevant 4-month period of time, there is also interference, but at the same time, it can be reflected by the other parts of the record, meaning the mother testified that she often would text the grandmother for visitation when she was allowed to do so. Again, for the first 3 months of the facility, she's under lockdown. She couldn't leave the facility, but once she was able to, she was given that opportunity. Grandmother refused to respond to her calls or take her calls. So yes, there was interference even during the 4-month relevant period of time. I'll also point out, as it relates to the ability and willingness to care for a child, the very evidence that this court needs to prove otherwise is the evidence that they have a third child, Aurora, who lives with them, has lived with them their entire life, and they care and provide for this child. To suggest that they can't care and provide for this child's siblings is simply false. In fact, that's one of the best interest arguments as well. We are denying these two children the right not only to see their parents forever and ever, we're denying them the right to see their sibling because the grandparents have filed for termination, even though they do not have a valid order from the juvenile court that grants them custody yet. They have a temporary custody order. They don't even have a valid order from the juvenile court granting them custody. And I'm also out of time.
Thank you, counsel. You have your time for rebuttal.
Thank you.
Hear from the appellees, please.
Good afternoon, your honors. I'm Ivy Gardner. I represent the Ridens in this case. And we are asking this court to uphold this Chancery Court's opinion in the trial court. The Nichols arguments are simply not supported by the record. We do commend that their life changes in this matter and hope they do well, but that doesn't help the two children involved now. I've been in this case since day one and have watched both of these parties suffer from addiction and get better from addiction. And like I said, we commend them for that. However, these two girls know no one else. Adaline has lived outside the Ridens' home for 9 days total. And those 9 days, even according to Ms. Nichols' testimony, were full of addictive behavior. Lila has been with the Ridens since she was a few months old. She's now walking, talking, doing great. Both girls are in a loving home and a great home. This court has found that another sibling does not affect a termination petition. And that was in NRA CDB from 2000. A child born subsequent to these proceedings has no effect on a TPR. Like I stated, the court's bound by the facts of this case and the law. The relevant time period here is from May 20th of 2019 until September 20th of 2019. The chancellor even gave them the benefit of the doubt during the hearing and backed that up to the 4 months preceding rehabilitation. This court has also held in Re Gavin that entrance into rehabilitation does not excuse failure to support or failure to visit. The trial court clearly found by clear and convincing evidence, which is highly probable by everyone's testimony, not just my clients, but Mr. Nichols and Miss Nichols' testimony, that there was a failure to support, there was a failure to visit. They have not manifested an ability to regain custody, and it's in the best interest of these girls to remain where they're at. As far as the failure to support, there's never been support ever since day one, especially for Adaline. The Rydens have raised her. There's been no diapers. There's been nothing except for the 9 days. Miss Nichols worked. She's worked previously in Adaline's life and still not supported her. As you can see, she's here today. She's able-bodied, just unwilling to work at this point. And she's the only one in Adaline's life as a parent that has that obligation to support. There's never been a father established. We included him in the TPR petition, but he's never, ever shown up. Miss Nichols acknowledges her obligation to support. She acknowledges that she knew it. She just didn't do it. And that is her testimony, the Rydens' testimony. It's all over the record. As far as her not knowing their address, that's simply not true either. And on in the transcript, she admits that's not true. Opened their home for her always, on multiple occasions, until the incident in February of 2019, when she had the girls in the vehicle, unseatbelted, and ran into the side of the home and a vehicle and left with them. That was the last time she's been there. She knows where they live. They've not left. They've never changed their phone number. She's well aware as to how to get a hold of them. She chose not to until after this petition. Christmas gifts one time is not enough. That's not even token support. As far as failure to visit, both of these parents, both Mr. Nichols and Miss Nichols, were present in the juvenile court, and it was explained that they could have free counsel. They chose not to do that. They would hire their own counsel. That was the last time anyone saw them. They made no efforts to obtain counsel. They made no efforts to get appointed counsel. They just disappeared. And next thing we knew, they were in rehab. The contact after the petition, this court has held time and time again, it's the 4 months preceding. That's statutory for a reason. We have to have a time frame in order to terminate these rights. After the petition's filed, it's too late. You know, at the time of the termination petition, Adaline was 5, and Miss Nichols had had her 9 days out of her life. That's a little too late at that point. They had Lila for a few months. Testimony actually showed from their witness, once they were allowed to leave rehab, they chose to do so and come here and visit her in this county, but never once reached out to see the girls. I think that was the most impactful testimony in this trial, when their witness got on the witness stand and said, oh, no, they come and visit me often. And they've never reached out to see the girls. They both acknowledge during the trial that the custodians, the Rydens, when you get down to it, actually did not circumvent their visitation or their support. They simply said, have your attorney contact my attorney. Never once did that occur. There was no communication between any of the attorneys. As far as the ability to manifest and regain custody and the willingness to regain custody at any time after the juvenile court order, these two could have gotten free counsel and petitioned the juvenile court for visitation and eventually for custody. They didn't do that. They chose not to do that. Even after the petition was filed, they chose not to take any steps to ask either court for visitation during the pendency of this petition. They just ignored it. They've never sought visitation with either court. They never made any effort whatsoever until the petition was filed. And again, that's too little too late. As far as the best interest factors, I feel like the chancellor did a really good job going through those. There's 9 in which he can choose from. He weighed all of those factors heavily into the Rydens' favor. He did commend Mr. and Mrs. Nichols for the home they have. It seems like a nice home. However, the fear of relapse is a huge issue for both of them. Hopefully that doesn't happen for Aurora.
Counsel, I'm sorry to interrupt you, but you know, the fear of relapse, I mean, tell me how that works. I mean, every recovering addict has the fear of relapse. Is that always going to be a factor that prevents their from remaining parents of the child? I mean, if you're once an addict, is just the fear of falling back sufficient?
No, Your Honor, I don't think so. However, Ms. Nichols has established a pattern of behavior of relapse whenever she gets the girls back. But as far as that factor alone, no, Your Honor. With all the factors weighed, especially considering the girls, this is the only home they've ever known. They don't know these people. They're strangers. And the Rydens have raised them. They have a family unit there. They're safe there. There was pictures of the home in this trial, but that was about it. You know, neither parent has made a lasting relationship with either child due to the failure to support or visit. The effect of these girls, if this court or the Chancery Court were to remove them, would be great. Both Rydens testified to that, in that these are complete strangers to the girls. And anyone that's a parent should understand that small children, especially if you drop them off with complete strangers, they're going to have a horrible time adjusting. And to think that these girls would have to do that is not in the best interest for them at all. Again, the court found that there is just not any positive for the girls to be removed from the Rydens and given back to these parents. They've done nothing as far as the 4-month period goes. And as far as willful, this court's found that that's intentional or voluntary inaction. Both of the parents admitted during their testimony that they knew of their obligation to support and to visit. they had the capacity to do so. Even during rehab, they had the capacity to reach out, visit with these girls on their home passes or whatever they chose to do. FaceTime, technology's a wonderful thing as we're Zooming for a Court of Appeals argument. But they had all sorts of avenues they could have used while they were rehabilitation. They chose not to do that. There was no attempt to perform those duties by either party, and there's no excuse for not performing those duties. You know, this is not an example of young parents. They are young, but they're not 18, 19 years old. They're well aware of their parental duty, especially Miss Nichols. She had Adaline for years before she had Lila. And she chose to not parent Adaline. So at this point, we would ask the court to uphold the Chancery Court's decision and find that the Chancery Court found by clear and convincing evidence that these parties failed to support, failed to visit, failed to manifest a willingness to regain custody, and that the best interest of these girls would be to remain with the Rydens and allow them to have a forever home with the Rydens.
Anything further, counsel?
No, Your Honor.
All right, thank you. We'll hear from the appellants in rebuttal.
Yes, Your Honor, as it relates to failure to manifest an ability to parent, Your Honor chimed in and asked Ms. Garner about that possibility of relapse and how that relates. Well, there is a legal standard. There's a two-prong standard. That prong would fall under the substantial harm prong. And it needs to be not a minor thing, not theoretical, and sufficiently probable that a reasonable person would believe that the harm is more likely than not to occur. Your Honor, this was not utilized by Chancellor Thurman in his summation, in his ruling, nor in his written ruling, I believe, that was submitted to the court on the 29th of 2020 of October. And we conclude that clear and convincing evidence has not been established on that. And as it relates to the first prong of that, an ability and a willingness to parent utilized by showing lifestyles and circumstances, as Chancellor Thurman said, they've made a remarkable recovery. So we would contend that on both best interest and the best interest categories that tend to fall in line with failure to manifest as well as manifest, that has not been the case. And finally, Your Honor, as it relates to that 4-month window, we're not contending, mother is not contending that that is not the 4-month window by law. However, as Henry Braylon S. states, we can look to previous times before the 4-month window to say, you know, that behavior of interference can be looked at. And it's our contention that the same logic should apply to the 4-month or any time after the 4-month window. And Exhibit 12 shows several instances. Please let me see my kids. Please let me see my kids. No response. And not the response of have your attorneys get in touch with our attorneys, which, Your Honors, I would conclude that the parents are under no obligation to seek court assistance in enforcing a previous order on visitation rights, which gives the Rydens, it's at their discretion. Why would an attorney need to call another attorney to say, hey, what's their discretion? That seems unreasonable to me. And though utilizing the courts is a, you know, this court has ruled that that can be persuasive, I would argue that the courts also said they're not obligated. And it would be unreasonable for the Rydens to make their attorneys get with another attorney, even if they did, which I think Exhibit 12 shows that that did not occur.
All right, counsel, thank you. Mr. Bennett, we'll hear from you, your client.
Yes, sir, Your Honor, and I think it's important to note that
if this court does not grant termination, this court overturns termination.
We've lost you, Mr. Bennett. We can't hear you.
I apologize. This court well knows that if this court were to overturn termination, that the children don't immediately go home to the parents. So that argument just simply doesn't hold any weight whatsoever. What it does allow, it allows these children to have a relationship with their real family. The home that they live in now was described as a great home. It is a home where the mother suffered sexual abuse from, and that the grandmother did nothing to protect her. It is a home where the step grandfather displayed his private parts and lost his job as a result of that. What happens when these girls turn 16 years old? Is that also going to be a great home for these girls to live in that scenario? Truth of the matter is 95% of all children, when they turn 18, go looking for their real parents. They want to establish and have a relationship with their real parents.
Counsel, let's call them, find some term other than real parents. I mean,
Their birth parents.
thank you.
Thank you.
Mr. Bennett, just for clarification, the allegation by Ms.
Can we
Nichols.
stop my time, please, if she's going to say something? Oh, I'm sorry.
No.
You're the judge. I thought you, I'm sorry. I thought you were counsel.
The allegation with respect to the stepfather or the dad and the sexual abuse, that's not the same stepfather who's with the girls now, correct?
No, the allegation against the abuser to the mother is not the same person living there. But that particular stepfather has issues as well that were played out in there. But to suggest that there was not interference by this grandmother, here's my problem, is this grandmother, at least in my opinion, failed her daughter miserably. And she's trying to now fix that through her granddaughters. But in doing so, she's willing to destroy every relationship that these children will ever have with their birth parents. And thank you.
Thank you, counsel. I didn't mean to imply anything by the term real parents, but real parents involved can include a lot of different family situations.
And likewise, I apologize to Judge Davis when she entered. I thought she was opposing counsel, and I apologize for that.
All right. It's one of the drawbacks of Zoom.
Yeah.
Okay, our thanks to all counsel. We appreciate your briefs and your oral arguments today. I think we understand the issues. You presented them well to us, and we thank you for that. Mr. Hibner, if you'll please recess court until 3:30.
This honorable